An introduction to Indonesian law. Sources of law. There are three types of sources of law in general, namely historical, sociological, and philosophical. In historical perspective, all written and other sources from where the study on law that existed in a certain time, people, and territory can be made. For example, in the form of legislation, regulation, politics, deed, and other non-juridical material, such as literature, inscription, etc. And regarding what the lawmaker has derived to create the law or preparation of legislation. In sociological perspective, factors that have actually influenced to cause the law applicable, facts and conditions become social demands for creating the law. Law is nothing more than a reflection of social reality. Law, therefore, is conditioned by political, economic, cultural, religious, geographical, and social factors. In philosophical perspective, the sources of law is justice and fairness. Justice in the sense of objective justice is an ideal human being that represents the ideal of moral good. The ideal of justice is represented by an ideal of social order.
The system of law that is implemented in Indonesia is the civil law system. Now, why does the civil law system apply in the Indonesian legal system? The civil law system was implemented as it was the legacy from the Dutch colonial times. Then after the independence, Indonesia started to create and establish its own modern law. In civil law system, all of the laws are essentially codified, where the system does not apply stare decisis, which means that Indonesian judge is not bound to the previous decision made by the past judge on dealing with the similar case. This system, stare decisis, belongs to the common law. However, the version of Indonesian civil law has been modified, in which the laws and regulations that are currently applied were influenced by customary law and Islamic law. Customary law has already existed and implemented to solve the disputes happened in this society even before the Dutch colonialization. In Indonesia, each region has different customary laws. While Islamic law was created to handle cases such as marriage, divorce, and inheritance. Now here are the sources of Indonesian law. There are 5 sources of law that are currently being implemented in Indonesia. The 1945 Constitution, in which is the basic law and regulations of Indonesia, law and government regulation in lieu of law, regulations, customary law, which is traditionally the basis to resolve disputes in the local society, and Islamic law, which has the function to resolve disputes between Muslims in personal and family law matters. The hierarchy of law in Indonesia. Based on Article 7, Paragraph 1 of the 1945 Constitution, which are the 1945 Constitution, law or government regulation in lieu of law, government regulations, presidential regulations, and regional regulations.
Forms of law in Indonesia. There are 2 types of forms of law in Indonesia, namely written law and unwritten law. Written law are law that codified in a book or regulation. For example, KUHP or criminal book and marriage law. Unwritten law are law that form from the habits of society or from generation to generation from their ancestor.
Next is the law based on the time of entire into force. Number 1 is Ius Constitutum. Ius Constitutum is legal provision that apply at a certain time and place. Why Ius Constitutum called a positive law? Because positive law is a formulation of laws regarding social life, which is determined by certain community powers and applicable to certain communities that are limited according to place and time. Ius constituendum. Why ius constituendum called negative law? Because ius constituendum is a law that is aspired to in the state's life, but has not yet been made into laws or other provision. Next is legal content in Indonesia. It's divided into two types. Number 1 is public law and number 2 is private law. Number 1. What is public law? Public law is a set of rules that govern the relationship between private individual or private organization and public bodies like government department and local authorities. In general terms, public law deals with issues that affect the general public or society as a whole. Some other laws that fall under this public law are administrative law, constitutional law, criminal law, municipal law, and international law. Number 2. What is private law? Private law is applies to any circumstance related to relationship between individuals in a legal system. Therefore, this type of law governs the relationship between individual and government. This is also to us common law. It includes the law of property and trust, family law, the law of contract, and the law of tort. And the next, the existence of law in Indonesia. The proclamation of Indonesian independence gave birth to the Indonesian legal system. First, Indonesia is free from colonial rule. And the second, the Indonesian nation takes the decision and juridically implement its own laws.